Thank you all again for joining today's webinar brought to you by the Tribal Law and Policy Institute and the Tribal Judicial Institute at the University of North Dakota School of Law. Today's webinar is titled Attorney and Lay Legal Advocates, Ethics and Professionalism in Tribal Courts, and will be presented by Michelle Rivard Parks, the Associate Director at the Tribal Judicial Institute. I will now turn it over to Michelle to introduce herself and to get us started.
Hello and welcome everyone to today's webinar. I just kind of as an introductory measure, I'll tell you a little bit about myself. I currently serve as the Associate Director of the Tribal Judicial Institute at the University of North Dakota School of Law, where we are a training and technical assistance provider, and we've been providing those services to communities for over 30 years. Prior to that, I served as the chief prosecutor for the Spirit Lake tribe, which is a tribe here in North Dakota, and I continue to work with that tribe in the capacity of legal counsel, working with their tribal government. Additionally, I have done some work within the law school, teaching courses in federal Indian law, a tribal economic development, and the lawyer class, as well as a class on tribal law. And lastly, I currently and have for about the last 9 or so years served as the Chief Justice of the MHA Nation Supreme Court, which is a Supreme Court for one of our tribes here in the western part of North Dakota. So I've been around tribal courts for quite some time. I myself have served as an attorney within tribal courts and also as a judge. And one of the topics that I think comes up a lot, both in tribal courts and in courts at the state and federal level, are questions about attorney ethics and standards. And that issue has also come up when we are referring to lay legal advocates. And we're going to discuss a little bit about the distinction between a lay legal advocate and an attorney, and how ethical standards and rules might be applied or necessary for both within tribal courts. So, with that said, we're going to go ahead and we're going to get started on today's webinar. So as we move through our session here today, we will invite you, of course, to type any questions that you might have into the chat box, and we will either try to respond to those during the course of the webinar or at the end, whichever seems most time effective and feasible. But for today, what we're going to start with is a discussion on what are professional ethics in order to kind of get us onto the same playing field, if you will, and understanding of what we're talking about when we're talking about professional ethics. We're also going to highlight why professional ethics are important. We'll discuss some of the issues that ethical rules might commonly address when it comes to legal representation by attorneys or lay legal advocates. And we'll also talk a little bit about some of the options that a tribe might have to move forward with implementing procedures or establishing forums that can be put in place to both guide professional ethics and enforce those ethics within your tribal communities. And then finally, we're going to look at a couple of examples from the field. What we have done is we've pulled a couple of examples of codes that you might want to look to if you're interested in either establishing some professional ethical standards within your tribal justice system, or maybe you're looking to enhance some of those professional standards that you already have in place. So we've given a few different examples. We will give those at the end. And then also there are a couple of cases that I was hoping to highlight at the end of the webinar that will kind of demonstrate to you how these issues might arise within a tribal justice system, how these ethical standards might be applied to address issues, and what some of the resolution to that may be. Okay, so first of all, what are professional ethics? And when we're talking about professional ethics, we're really talking about the established rules, principles, or standards that are put in place to govern the conduct of professional lawyers and lay legal advocates who are working within your tribal justice system. So think of these as very more formal rules or formal principles of formal standards that can be enforced, whether they be enforced because there's been an infraction or whether a client of a professional lawyer or a legal advocate feels that that person has not done their job or maybe they've acted in an unethical manner. We want to have both rules in place to help us make determinations on such questions. And we're also going to want forums in place to help with the enforcement of these types of standards and procedures. So, why are professional ethics important? There's several reasons, and this is certainly not an exhaustive list as to why professional ethics are important, but certainly some of the points that you see before you here are important. And so, professional ethics can help to improve the quality of legal services to clients. One of the ways that they can do that is they can help to ensure that when an attorney is providing services to clients, they are protecting the confidential nature of communications. They're being honest with their clients and they're being fair with their clients. Also, I think I would add to this in terms of quality of legal services that they are being attentive to the case at hand. I think that's a tendency that clients, when they do have a complaint about attorneys, it's often around the communication, whether they feel that their attorney is not communicating with them effectively or frequently. And, so the professional ethics can help to set standards for what is an appropriate amount, like frequency of communications, and things of that nature. And that can help set expectations for both the attorney and for the clients. And certainly, we want to make sure that any legal services that are being provided are done so in an ethical manner. It's important that we have ethics in place, not only for our judiciary, but also for the attorneys that are representing clients in our tribal justice systems, as it lends itself to the integrity of the overall tribal justice system. And for any of you who were able to join the discussion on a prior webinar about judicial ethics, Mr. Stephen Pevar discussed the real importance of taking steps to ensure that whatever rules and procedures and forums we're implementing, that those are implemented in such a way that they foster a strength of integrity within our tribal justice system. And they send a message to those that might be engaging with our tribal communities that the tribal justice system is a fair and equitable system. Professional ethics are also important to help avoid conflicts of interest and improve the competency of professionals who are providing legal services. So, again, setting standards so that attorneys are aware of what is expected of them when they're providing legal services. Putting standards in place to make sure that attorneys or lay advocates aren't representing the interests of clients who might have competing interests is very important. And so that's kind of gets us into this conflicts of interest discussion. And we're going to talk a little bit more about that as we move forward as well. And then also, I think professional ethics are important in the from the position of the court or the judge. ethical standards can help to ensure that the attorneys and the lay advocates who are appearing before your tribal courts and your tribal judges conduct themselves in a manner that is respectful to the court and respectful to the tribal justice system. And I do recall, there was a time when I was a special judge in a trial court, and I recall the attorneys in the courtroom, they were engaging in a dispute with one another, and instead of advocating for their clients, they were arguing with each other and verbally accosting one another inside of the courtroom. And that certainly is the type of conduct that we don't want to have happening in our courts. And those professionals who are providing legal services in our courts, we need to have high expectations for those behaviors. And so having rules in place, so that the judge in that situation could hold those attorneys accountable, for example, is an important step towards also improving our judicial responses and capabilities to maintain a level of decorum in our tribal courts or our forums that are in place for the adjudication and resolution of disputes. Um, so also, professional ethics are important in tribal courts because, again, they regulate the conduct of attorneys and lay advocates who are practicing in the courts and providing services in tribal jurisdictions. We know that tribes have inherent authority to regulate conduct and to pass legislation that applies within their tribal courts and their tribal forums. And in this way, professional ethics and ethical standards in tribal justice systems are well placed to ensure that tribal values are also incorporated into ethical standards. And there is actually a good article that I want to point out to you, and we might be able to drop a link to this into the chat before, or if anybody wants it, perhaps they can reach out and we can get it to you after. But Lauren Van Schilfgaard, who actually was a former employee of the Tribal Law and Policy Institute and is currently an assistant professor at UCLA School of Law, wrote an article in 2020. And it's called, the title of the article is Indigenizing Professional Responsibility, the Role of Ethics in Tribal Courts. So if you're interested to kind of explore a little bit more on how you might approach the development of your professional ethical standards in a way that incorporates tribal values, I think that article that was written by Professor Schilfgaard gives some good recommendations for you. Also, I think professional ethics are important because they provide safeguards for attorneys and legal advocates that are practicing in tribal courts. Earlier I've talked about, the expectations of clients and, having clients that are disgruntled or unhappy with legal services that, making sure that there are ethical standards in place can protect the interests of the client, but they can also protect attorneys and lay advocates against unreasonable expectations that clients might have. For a lot of people that are providing legal services, they may have a lot of different cases that are all pending at the same time. And you might have some clients who have an unreasonable expectation that there will be daily or sometimes multiple daily forms of communication between themselves and an attorney. And so that might not be realistic and it might not be reasonable. And so having some ethical standards in place that can guide what those expectations can or should be can be a measure of protection for attorneys as well against, things like malpractice, litigation, and things of that nature. And then also, again, really these ethical standards help ensure fairness and equality within the justice system, and an important part of supporting and fostering perceptions and realities that the tribal justice systems that are being built by various tribes have integrity, that they are fair, they are neutral, they are impartial, and there are mechanisms in place to ensure that people who are utilizing court systems um, are also having access to legal representation that is going to be fair and appropriate, and up to par, if you will, with what should be expected in any other justice system within this nation. Okay, so who should ethical standards apply to? If you're creating professional ethical standards, you've heard me reference a couple of terms. I've said professional attorneys and lay legal advocates. And I wanted to break this down because what we've seen is that in some tribal communities, accessing professional attorneys can be a challenge for litigants. And as a result of that, many tribes have incorporated into their laws and their codes opportunities for lay legal advocates to practice and represent clients in tribal courts. And so it's really, you're going to have to look at your tribal laws and your tribal codes, and there should be provisions in there that will distinguish between professional attorneys and lay legal advocates, or clarify whether just professional attorneys can represent the legal interests of clients, or whether within your tribal justice system, lay legal advocates can also represent clients. And before I go too far down this, when we see this term advocacy, there are a variety of different individuals within tribal justice systems who might be advocates, but there are various types of advocates. So, for example, we may have victim advocates who are direct service providers, linking victims of crime to services they need in order to be safe or to foster healing, things of that nature. And in some instances, those victim advocates might also be able to come to court with a victim, but they may not always be speaking in the court or verbally representing the legal interests of their clients. In other tribes, that may be the case. There also might be various other types of court advocates, but when we're talking about lay legal advocates for purposes of these ethical standards, we're talking about those individuals who are providing legal representation both in and outside of court to clients in a manner that is very similar to that which a professional attorney would provide legal services. And so if we, a big distinction between the professional attorney and the lay legal advocate, it might be the level of formal education. So our professional attorney may have a Juris Doctorate degree and licensure, a licensure by a bar, for example, which would be typically like they may have taken a multi-state bar exam and be licensed by a state. They might also be licensed in the federal courts. And your tribe may have a process for licensure as well. But typically, the professional attorney is going to have that level of formal education coupled with a licensure element. With our lay legal advocates, oftentimes there's a distinct and different level of formal education that will be involved. And with the distinction with the formal education, it may be that the lay legal advocate has a high school diploma. It may be that they have an associate's degree or a bachelor's degree. What the criteria are for who may serve as a lay legal advocate in your tribe will be dictated by your tribal code. But typically, a lay legal advocate is not going to be someone who is licensed um, by a bar exam. So they're not a licensed attorney. And I do see there are some emojis on the screen. I haven't touched anything, so I'm not sure how those are coming up, but let me see if I can close them. There we go. Okay. The other thing about the distinction between lay, or with lay legal advocates, and in a couple of the tribal jurisdictions where I've worked as an attorney and or a judge, lay advocates and professional attorneys are both able to represent the legal interests of clients. And as I said, the codes in those tribes dictate who will be considered a professional attorney and who will be considered a lay legal advocate. Where we've seen some distinctions in those communities is with these professional standards. So some of the tribes have no professional standards reflected in their tribal codes, but they might defer to the professional standards for the jurisdiction that has licensed the professional attorney. So, in other words, if the attorney is licensed in the state of North Dakota, they may be admitted to practice within the tribe. And then, if they are practicing within the tribe, they're held accountable still to the ethical standards as outlined by the state. And some tribes will have their own set of professional conduct rules. And I do see that Joy just put into the chat box that for their tribal code, they reference the American Bar Association. And we're going to talk about that actually coming up. So I'm glad you point that out, Joy. The American Bar Association has some model rules for professional conduct, and we'll highlight those in a minute. So the approach that your tribe takes to defining or distinguishing between professional and lay advocates may vary, but it is important that if lay advocates and professional attorneys are representing the interests of clients in your court or justice system, that there be ethical standards applicable. And just for a quick rationale or a little story for you, one of the things that was experienced within one of the jurisdictions where I've provided some services is that we had some increase in economic activity within this tribe. And as a consequence of that, there was also then some increased conflicts associated with business arrangements, and things of that nature. And so there was an increased need for legal representation. Unfortunately, the number of professional attorneys providing services to that tribe hadn't increased at the same level as the need. And so what we found were a lot of people that were coming forward as lay legal advocates, and they met the criteria, which I think in that tribe was that they had to be a tribal member of a certain age. They had to have a demonstrated understanding of tribal code, tribal law, and then they could provide these legal advocacy services. The problem is that there was not a specific provision in the code that indicated that those lay legal advocates would be subjected to any type of ethical standards. And so we had reported incidents coming forward of people that were providing advocacy services doing things like charging these very large retainers, for example, like, you want me to represent you in a child custody matter, I need a $20,000 retainer. And not only that, not only was the retainer really high, but in addition to that, without ethical standards, there was no requirement that lay legal advocate set that money aside and only draw upon it once services were rendered or anything like that. So you can see how, like, even on the fiscal sense, that having lay advocates presenting or representing clients without having ethical standards can give rise to some very difficult issues for clients. And also, as I mentioned before, it can leave the lay advocate open to some liability if a client is unhappy and wants to sue them, regardless of whether or not that client is being reasonable in their thoughts. Okay. So when we're looking at resources, we kind of have now an understanding of what these professional rules of our ethical rules are and what their purpose is. We have an understanding of who we would want these to apply to. So really those people that are providing legal representation within your tribal justice system, which may be your professional attorneys, it may be your advocates. You might have some tribal codes already that outline some measure of ethical responsibilities. You might have code provisions that refer to other outside ethical standards that would be drawn in and applied for those who are working in your tribal justice systems. Or you may want to develop your own. If you're developing your own, or maybe you want to evaluate what it is that you have in place already, there are a few resources that you might want to consider looking at when kind of doing that assessment or developing your codes. And one is the American Bar Association. So the American Bar Association has what are called model rules of professional conduct. And really what these are is they're a set of, it's like a sample or a model set of rules to guide the professional conduct for attorneys. And within these model rules, a lot of state jurisdictions have pulled from the ABA model rules to establish their own um, set of ethical standards within their states. And some tribes, as you've seen by the earlier comment, have also maybe referred to the model rules, whether they've adopted them in whole or part in their tribal codes, is really going to be done on a case by case basis. There are also a number of different tribes that have gone through this process already and have implemented professional ethical standards within their tribal codes. And I always think it's a good idea to take a look at some of those other tribes, particularly if they're tribes that are similarly situated to yours, in looking at how they may have approached it and some of the considerations they might have taken into account. And one of the reasons that I do like this approach is particularly earlier when I had mentioned that, within the sovereign status of tribes, there's a great opportunity here to not only adapt model rules that were created in kind of a generic and justice system wide sense, but also to ensure that your tribal rules and reflect your cultures and your values. And so considering what those tribal customs and values are when setting forth your rules can be a good thing to do. And again, looking at the examples provided by other tribes can help you to see ways in which that has been done. The one thing about the ABA model rules of professional conduct is that they were really developed to guide the actions of professional licensed lawyers, and they really didn't contemplate lay legal advocates. So if you're looking at the model rules, you will want to make sure, and if you're adapting those or utilizing those, you might want to have some tribal code provisions that clarify whether those rules would be applicable to both professional attorneys and lay legal advocates, or just one or the other. Okay, so at this point, we have an understanding of what professional ethics are, who they might apply to. We've gathered some resources that will help us really to assess what our ethical standards look like now, or perhaps create ethical standards where those did not previously exist. So I want to move into a discussion on some of the issues that professional ethical rules or standards will commonly address. And so one of the kind of common rules or set of rules that you will see reflected in ethical standards will be those that will set forth the qualifications that are required in order to become licensed by the tribe or admitted to a tribal bar. And particularly after the enactment of the Tribal Law and Order Act of 2010, and then also what we've seen following the reauthorization of the Violence Against Women Act in 2013 and 2022, attorney qualifications and the development of tribal bars and tribal bar examinations has been on the increase. And part of the reason is that those laws, the Tribal Law and Order Act and the Violence Against Women Act, made some opened some doors or provided some opportunities for tribal justice systems to impose greater sentences in tribal courts, particularly in terms of jail time and fines. They've also, on the Violence Against Women Act, there's opportunities for tribes to be able to hold non-Indians accountable who are committing certain qualifying offenses as defined by that law. But both the Tribal Law and Order Act are available to tribes that have certain components or infrastructure in place. And so part of the discussion around that has been within that infrastructure, having law trained or licensed judges, having law trained or licensed attorneys or legal representatives has been part of that discussion. And so looking at what it is that you need in order to be qualified by the tribe to serve as a professional attorney or as a lay legal advocate is going to be dictated by tribal code. And so one of the good starting off points for anybody who's looking at tribal codes and deciding whether you might want to amend or add to your codes is looking for whether or not this distinction is drawn in the code itself. And then it's really up to the tribe to determine what the qualifications for both will be. Um, and whether or not they want to have specific ethical standards that apply in the same way to professional attorneys as they do to lay advocates, or whether they want some of the professional attorneys to have maybe even more ethical standards applied to them than the lay legal advocates. And both approaches are an option. With the lay legal advocates, they may not be required to have some of the formal education. But, if the tribe has a bar exam, it could be that the lay legal advocate has to pass that tribal bar exam in order to be licensed. Again, that's a decision for you as the tribe or within your own tribe to determine how you want to go about authorizing lay legal advocates and professional attorneys to practice within your courts. With our professional attorneys, it's very, very common to require that they've got a doctorate degree, such as a Juris Doctorate, which is kind of some formal legal education, and that they've successfully completed a bar exam. Maybe they've taken an oath and are paying licensing fees. So, again, there are several examples of code provisions that will apply to professional attorneys and lay legal advocates. And sometimes those are reflected also, and those various definitions are reflected within the professional ethical rules that are established. Okay, another common area that we see professional ethics apply to are attorney-client rules. So these sets of rules really will govern the way in which the attorney and client relationship develops or evolves, and these provisions will apply duties and responsibilities to the attorney and will kind of largely dictate how they are supposed to be performing legal services in terms of being diligent in the legal representation, in terms of the frequency or effectiveness of communications with clients. Attorney-client rules will often establish or reference fees. And I know this is a big one, like I had mentioned from the earlier example. What is an appropriate fee? And a lot of the professional standards rules will indicate that, there's kind of a customary practice or industry standard in your region for what would be appropriate fees. It might also be that there are other considerations to be taken into account um, when fees are applied, such as the level of education, the professional licensing, the level of experience that either a professional attorney or a lay advocate has. So, for example, it would be common in a law firm, for example, to see that a junior or a person who is just entering, maybe just graduated law school, they're in their first year as an associate within a law firm, their hourly rate of pay or the hourly rate that they billed to their client may be much lower than the hourly rate that is billed by a managing partner who has extensive expertise and has been providing legal services for, let's say, 30 years. So there are a number of different ways to address fees and to kind of set some criteria within the attorney-client rules section of your professional rules. Confidentiality is another big one. When we're looking at confidentiality, the communications in performance of legal services between the attorney and their client are typically governed, are typically privileged, and the attorney is bound by confidentiality not to disclose a lot of the information that is discussed between the attorney and the client. There are very minimal exceptions to that. Interestingly, though, and if you do not have ethical standards applying to the lay advocates, um, it's unclear, right, whether or not the communications between that lay legal advocate and the client are covered by rules of confidentiality that may be found within your codes, unless your codes are specific on that, and unless your professional ethical standards are specific on that. So this provides another opportunity, not to also protect the integrity of the conversations if you are allowing lay legal advocates to represent the legal interests of clients within your court system. There also may be provisions within these attorney-client rules in approaches that need to be taken when a client has diminished capacity. Maybe if they have, for example, a brain injury that impacts their cognitive functioning, or they have some other issue that may be affecting their capacity. There are some special rules that will apply oftentimes to those. And then also the rules will typically govern the termination of the legal representation and what is an appropriate manner to end that attorney-client relationship. So, kind of going back to, do you end the relationship through text, or are you required to submit a formal letter and, notification to the court that you are withdrawing from the case? Do you have to state reasons? Do you not have to state reasons? And again, your rules can kind of set forth some of those expectations. Competency and diligence is another area that we see where we have ethical rules that are going to be applying. And this is really important. I think there's a little bit of a misunderstanding sometimes in the legal field that someone has gone to law school and therefore they're qualified to represent anyone on any issue in any case. When the reality may be that you've got an attorney who has extensive knowledge in family law, but if you approach them and ask them to represent your legal interests on a corporate matter, they may have no understanding of corporate law. And so ensuring that the attorneys and lay advocates who are taking on a case and accepting payment for those cases possess that legal knowledge and skill set to represent clients is important. And if an attorney doesn't have that, they should be not taking the case. They should, or disclosing that to the client. And if the client wants to allow them time to try to garner that knowledge, but there should be a process in place for that. And so that legal knowledge is a part of this, and other things that are often involved with this competency and diligence might also be communications and meetings with clients and witnesses in advance of trial. And unfortunately, I've witnessed this myself, even in recent years in courts where we've got attorneys that they read the file, they come into court, and that's all that they've done. And it's really that's difficult to watch as a legal professional because that is not the way that a legal representation should be approached. There should be some measure of communication with clients, and certainly some outreach to witnesses in advance of trial to make sure that the attorney or the lay advocate who is providing that legal representation is diligent in their services, and that they're appropriately prepared when they get to adjudication. Same thing with collection and review of evidence and information. A lot of times we'll be talking about criminal cases, which may involve some discovery requests and things be done in advance to kind of look at what the evidence is in the case. On the civil side, when we've got civil and family disputes, the level of advanced preparation may be even greater. And remember, the attorneys and the legal representatives should be aware that the court is not there to serve as their investigative body, right? There are procedures in place, and they should have an understanding of those procedures and how to utilize them in order to collect evidence. And so it really comes back to when people are being admitted and authorized to provide legal representation and to be compensated for that legal representation, there should be a certain standard in place to govern how they're providing those services, and that the services provided are being done so in an effective and competent manner. And the way that we can determine are they doing so in a competent and diligent manner is to have some ethical standards in place to guide that process. Okay, another area is attorney communications and transactions with clients. And again, I had mentioned a little bit about this earlier, but when attorneys or lay advocates are communicating with clients, you will want to take a look and make sure that those communications are covered by rules of confidentiality, and that also there are some ethical standards in place to make sure that the attorney is keeping their client reasonably informed about the status of their case. All too often we will hear situations of clients saying, I haven't spoke to my attorney and it's trial day today. Right? That really shouldn't be happening. There should be some measure of communication between the attorney or the lay advocate and their client in advance of any court proceedings, and other actions that are being taken. It's just a reasonable expectation. And particularly, we've got to be mindful. These are individuals who are being paid for these services. The other thing that might be other provisions that might be included within kind of the attorney communications section of an ethical code would relate to transactions with people who are not their clients. Okay. So when they're working with their clients, we would expect that the attorney or the lay advocate would be diligent. They would have reasonable frequency of communications to keep their clients informed, that they would be maintaining confidentiality surrounding those communications, etc. But what about when the attorney is talking to people that are not their client? When they're working with people that are not their client, you're rules may want to reflect, this is where your core values can come into play. Making sure that the attorney or the legal advocate is being honest in their communications. They shouldn't be falsifying or lying in documents, unlawfully withholding information from opposing counsel, for example, to try to bolster their cases. Um, if they are communicating, like if we're, say, in a civil case, for example, and the other party has legal representation, your ethical standards should direct them to make sure that they are communicating with the legal counsel and that they're not circumventing the other person's legal representative, and trying to cause that kind of difficulties in a case. And then also, your rules can set expectations of how communication should flow if they are communicating with a person on the other side of a case that is not represented by legal counsel. And then finally, there should be some provisions that speak to third persons and respecting the rights of third persons. And I'm going to move through these last few a little quickly here because I see we're coming up on time. So I've been talking a lot, but I'll try to move through these pretty quickly so that we have a few minutes for questions. Ex parte communications is a big area of the law where we see, complaints kind of coming in. So, in general, attorneys and lay advocates are not to be communicating with judges or jurors outside of a formal courtroom setting unless there's an exemption or they're permitted to do so by law or by a court order. And so, it's really important. That there are rules in place that will dictate this so that if an attorney or a lay advocate does try to move forward with ex parte communications with a judge, with a juror, or if they try to communicate with another litigant in a case in an unlawful manner, that they can be held accountable for doing so. Conflicts of interest are another big area, and these are going to prohibit the legal representative from kind of representing others where there's a conflict with the professional or personal interests of themselves or with their client, and this conflict can compromise their professional judgment. And so you'll want your rules of ethical responsibility to kind of define the duties and responsibilities that the attorney or lay legal advocate has to current clients, and then also making sure that your rules define any duties and responsibilities that they have to former clients. Because these conflicts can arise later on and after the legal representation has stopped. You want your ethical standards to also address fiscal issues. I had mentioned or provided you an example earlier of retainers. And a lot of professional ethical rules are going to require that if an attorney or a lay legal advocate is accepting a retainer or an advance payment, if you will, for the provision of legal services, there's typically they have to keep that in a separate account, and they are not to draw down on those costs until services have been rendered, and any unused portion should be returned to the client. So that would be typically what you would see under a retainer's provision in ethical standards. And there's a number of reasons for this. Like, let's say somebody accepts a $20,000 retainer and a case settles out within 1 hour. Well, is it reasonable to take $20,000 for a 1 hour's worth of work on a settlement, right? That would be an example. The other fiscal issue, which I had mentioned to you, are your provisions will want to address your attorney or lay legal advocate rates, and how you will determine whether those rates are reasonable or not. A lot of times, again, your codes will reflect that rates would be dictated by labor, skill, um, experience, or maybe the customary fee that's charged by others in the legal community in your area. Some other issues that you might want to consider in your tribal codes is respect for tribal sovereignty and adherence to law, tribal law. And you might want to include requirements that attorneys or lay legal advocates adhere to tribal customs or culturally specific legal traditions when applicable. So, some of our tribal rules of civil or procedure or tribal rules of criminal procedure or our tribal rules on expert witnesses, they may have some customary or traditional language or process attached to them. And we want to make sure that the attorneys and lay legal advocates are familiarizing themselves with the tribal law, with the tribal code, and that they are adhering to the standards that are set forth in that law and that code. Okay, I want to finish up with a short discussion on enforcing ethical rules and how do we go about enforcing ethical rules. One of the first things to consider are the people or the forums that will be put in place to enforce the rules. In some instances, tribal court judges will play a little bit of a role in enforcing rules, particularly when they are witness to attorneys or lay legal advocates who are not following or who are violating the ethical standards or rules that are in place within your tribal community. Of course, tribal court judges do have some contempt power, but there may be provisions or requirements that judges who are witnessing unlawful or unethical behavior report that misconduct that is observed by the judge so that the lay advocate or the attorney can be held accountable, which gives rise to the question of where would that report be filed and who will hold that individual attorney or lay legal advocate accountable. And the answer to this is that that's really up to the tribe of what type of forum you want to put in place to handle these disciplinary actions. For some, we've seen the tribes establish a disciplinary board. Some tribes have actually started their own tribal bar. And if they have their own tribal bar, it could be that that would be the entity where that would have handle the complaints associated with the actions of attorneys and or lay legal advocates. But there might be other forums established by the tribe to receive, investigate, and conduct hearings relevant to complaints on ethical violations. It's a little bit challenging to put your tribal court or your tribal appellate court in the position of doing this because they're really there to enforce, the overall laws of the tribe. So having a neutral and independent board or forum really, I think, is ideal, but that's my opinion. It is really up to the tribe to determine what forum might work best for you. Some of the common remedies that we see when a violation is found, an ethical violation is reported, and after investigation and hearing on the matter, it's determined that the attorney or lay advocate has, in fact, violated the ethical standards. It may result, and again, your ethical rules should reflect the potential remedies for a violation, but it may involve a reprimand, which is you violated, this is going on your record, don't do this again. It may result in a suspension for a limited period of time where they are not able to provide legal representation for 30 days, 60 days, 90 days, a year. And it may involve a disbarment. If it's an egregious violation, it may be that the attorney or the lay advocate is informed that they are no longer eligible to provide any legal representation to clients. Okay, examples from the field. And I don't want to say that I'm advocating for any of these, but these were a few code examples that I did find. Each kind of has a little bit different approach. And these is certainly not an exhaustive list. There are many other tribes that also have tribal codes that address ethics for attorneys. Lac de Flambeau has a code of ethics session. And what I thought was interesting when I looked at this is that they have a section for judicial ethics and they have a section for clerks of court ethics. And then they have one that is entitled Persons Practicing Before the Court, which of course may encompass more than just the professional attorney. Nottawasepi has court rules of professional conduct for attorneys, and it's quite an extensive rules of professional conduct for attorneys. Nooksack has an advocate's code of conduct, which I thought was interesting. And this is a code that is really written for advocates, although it does list a lot of the typical duties and responsibilities and standards that would be applicable to attorneys. And then Hoopa Valley also has a professional ethics code for spokespersons and attorneys. And the spokesperson is defined as any person that is duly admitted and recognized by the Hoopa Tribal Court Bar. So you see there's different approaches here, but there are ways to put professional ethical standards in place. But one of the big key things is making sure you're very clear on who those ethical standards are going to apply to. Okay, and the last thing is that we had some case examples, and I know we're running up here on about 3 minutes of time. So I'm not going to go through all of these, but there are a few examples that I did find of instances where attorneys had been kind of held accountable and for violations. And so in the first one, oh, wait a second. Oh, I'm in this first one. We In Re Lilly, an attorney was disciplined for accepting employment with the tribe's prosecution office while still representing a criminal defendant in a tribal court. So that's that conflict of interest situation. We've got some examples of lack of competency cases. In this first one, we had a Minnesota attorney who was representing a client in tribal court and was found to have violated the duties of competency and diligence when he was late and unprepared for a couple of court hearings. And he left a remote session without notice, failed to appear at a disciplinary hearing, etc. And then this last one I'll give you quickly on failure to maintain a separate retainer. This is not a tribal example, but in this example, we had an attorney in West Virginia who received a check from an insurance company on a life insurance payout. And it was about $60,000. And what the attorney did is they deducted $20,000 as a fee for legal services and sent the rest to the client. And of course, the client complained to the bar, claiming that the fee was excessive. And ultimately, the attorney was disbarred due in part to the violation. And also, there was another complaint that was pending. Okay, so with that, we have maybe 1 or 2 minutes here, I think, where we can open it to question. I have seen some things moving, most of which appear to be comments in the webinar chat. So hopefully you all have been following along with that. But Chantella, were you able to extract any questions?
Yeah, we actually have a few that popped up in the Q&A box. So I'll read through those. One of them you may have answered somewhat already in the PowerPoint presentation, but the question is, or the first statement, I've been thinking about how to tie in respect for tribal sovereignty into ethics responsibilities. And the part of it is it to require more on the admission side, require competency, and then outside attorneys appearing in tribal court and not understanding or respecting the application of tribal laws seems to still be an issue.
Yeah, and I think, even putting a generic statement in your ethical standards that, like a professional attorney or a lay legal advocate is required to um, adhere to tribal laws, applicable tribal customs and traditions within the tribal court, and that failing to do so may result in an action being taken under the ethical standards. That's one thing that you can do in the ethics piece. But I do think if you want to improve that from the onset and not get to the point where we have a violation, having things in place like a tribal bar exam. We've seen some tribes that their bar exam doesn't necessarily require somebody to be tested on all the laws, but rather is a tribe sovereign? Do they have a constitution? Are there cultural practices that can be employed? Those kinds of things. So there are various different measures to improve that, but I do agree that still remains a bit of an issue.
Okay. And then we have another question. It says, what considerations are key when thinking about regulating lay advocates, particularly around conflicts, when the tribal code states that only tribal citizens can serve as lay advocates and the tribe is a small community?
Yeah, I think that's a great point because, if you've got a really small community, it's likely that you're going to be related to somebody, or it's likely that you may have, represented the interests of a client at one point in the past, and then in the future tribal ethical standards and creating your own provides an excellent opportunity for this because you can provide that you recognize that it's a close-knit community, that the lay legal advocates, there's an increased likelihood that a conflict could arise. And so exemptions can be sought by if the lay legal advocate, if there is a conflict, they can get a written waiver from their clients, or unless they are related within and whatever the degree of relationship is, that they would not be subject to things, although that's more on the judicial side. But there are ways to kind of carve out some exemptions, I think, within the tribal code, particularly when you're talking about the lay legal advocates.
We have another question in that regard. How do lay advocates get paid for their services once licensed to practice in tribal court?
Well, that's something that could be placed in your code. If you want to talk about the fiscal provisions, you could dictate that, but it wouldn't be any different, or typically wouldn't be any different than the professional attorney. And in some instances, professional attorneys might require a retainer, which is kind of that advanced amount of 1,000 or whatever to, move forward with the case. But when attorneys do that, they have to set that money aside. That's just not a free $1,000. They set that aside into a separate account. And then they draw upon that as the services are being provided. And lay advocates could certainly do the same, but the payment's going to be directly from the client to the lay advocate. Another thing that we do see is sometimes attorneys are not taking retainers. They'll take on the case and then they will bill the client as they are providing services. So if they've provided a month of services and they've dedicated 20 hours to the case, they would give the client a bill or an invoice for those services, and then the client would pay them for those services, if that makes sense.
Thanks, Michelle. And then we have basically it's a case scenario, which advice would be sought. So I'm going to go ahead and read it. It's a little lengthy, but I think it's important. I'm a tribal prosecutor. The tribe I work for has a law that states the court and the prosecutor's office shall be independent from improper influence. No person, including elected or appointed officials or employees of the X tribe, shall attempt to improperly influence court proceedings or to interfere in any way with any tribal judge or tribal prosecutor in the performance of his or her duties. My council approved job description requires me to be a member of the state bar, which has an ethics rule requiring attorneys to not allow an employer to direct or regulate the lawyer's independent professional judgment. And then it says the tribe's organizational chart made me or made the executive director my supervisor. The executive director directed me to file a case that I did not think I had legal authority to file and told me that it was not up for consideration and that he didn't care for the ordinance I cited for not having authority to file the case. What are your thoughts on this situation?
Yeah, that's an interesting situation. So, as a former tribal prosecutor, I guess the best kind of approach or thing that I could say on that was, and this is where ethics become important, right? When you're a prosecutor, if you do not believe that you have a reasonable probability of conviction in a case, right? That's the general standard. If there's just not evidence, then you don't file that case. And that's typically because of ethics. It's an ethical violation to do that. We are not here to persecute, we are here to prosecute. Um, and so, I always took the stance that if someone was going to force me to try to force me to do something that I knew to be unethical, even if that meant I losing my job, I will lose my job before I will lose my license, right? So I think that's the first thing. I know that's not an easy thing to hear, but kind of what this does is it brings up a little bit of the issue of separation of powers. Um, Although, I mean, as a prosecutor, arguably you're representing the interests of the tribe. But yeah, I would say, you bring it to the director that there's just simply not enough evidence to support reasonable probability of conviction. If I file this case, I would subject myself personally to an ethical violation. I could lose my license to practice law, and I'm not willing to do that. And if they want to find somebody else to file the charge, by all means, they can do so. It may result in a loss of job. And I know that's not easy to hear. And unfortunately, that is something that attorneys and lay advocates are faced with is, um, you know, conducting ourselves in a way that is ethical, even when others don't want us to.
Thanks, Michelle. I'm not seeing any others that we could actually answer live. And so, I just
Mm.
um, wanted to double check the chat box real quick. And I see we did have some other resources dropped in the chat by Heather Torres. So I just wanted to say thank you for that. But I think that's it as far as questions.
Yeah, and I did note,
Oh, I'm sorry. One just
thanks.
popped up.
Yeah,
Sorry.
thanks, Heather.
If there's a conflict of interest with the judge and there are no other judges, every judge is related to one of the other parties. An appeals panel is also related, and the state doesn't take tribal cases. How do we get a case to federal or another tribe nearby?
Yeah, I think if you want it, this actually came up in the discussion on judicial. But when you've got conflicts of interest, if you're not able to get an outside judge to come in as a consultant on that one case, we call them conflicts judges. Others may call them something else. But if you're unable to do that, um, you could approach a neighboring tribe and try to enter into an agreement, where conflicts cases, you would help one another to resolve cases in the event of conflicts. And that actually came out on the webinar on judicial ethics yesterday, and I think is a very good approach. So it's a tribal to tribal collaboration that might help both be mutually beneficial to both tribes, where you could direct those cases elsewhere. In the MOU that you would put in place for something like that, you would want to clarify which tribal codes would apply, which tribal procedures would apply, which ethical standards would apply, etc.
Okay, thanks, Michelle. I think that's it. I'm not seeing anything else as far as questions. So if we can maybe advance to the next slide. Okay, Michelle, can we move to the
Oh,
evaluation slide?
I'm sorry, I
That's
forgot
okay.
I was controlling this.
That's
I
okay.
was reading the chat.
That's okay. All right, everybody. Wanted to say thank you for attending today's webinar, Attorney and Lay Legal Advocates, Ethics and Professionalism in Tribal Courts. And thank you again to Michelle Rivard Parks, the Associate Director of the Tribal Judicial Institute at the University of North Dakota School of Law, for joining us today. The webinar will be recorded and posted on walkingoncommon.org and will be sent out to our mailing list as well. And those links will be dropped in the chat box as well as a link to an evaluation if that works better than doing the QR code. So if you would all take a few minutes, that would be great. And just to note, this webinar is a part of a series of monthly webinars to support the development and enhancement of tribal courts, tribal justice systems, and intergovernmental collaborations. These webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, and the Tribal Judicial Institute UND School of Law. Attendees will receive an email with today's webinar recording and materials. And again, as a reminder, there's a link for the evaluation in the chat box and QR code on the screen. Please take a moment to complete the evaluation, as your feedback is greatly appreciated. And we want to thank you again for joining us today, and we look forward to seeing you in the future for another webinar.